Hello, I'm Karen Marsh from RG Law, and I'm joined by Donata Crossfield, Head of Wills and Probate at RG Law.
Hello, Karen.
Hi. So we've got a lovely topic, but a very important topic. What is probate, Donata?
Probate is a word that is used to describe the administrative process to deal with a deceased person's estate after they died. It is a process. You, of course, start with registering the deceased's death, arranging a funeral, and then you will start to collate the information about their assets and about their affairs. This will include notifying all the authorities, public bodies, pensions, banks, financial investment companies, collating all the information in. Unfortunately, there's no central register at this moment in time yet. Maybe something for us to think about for the future, where all the information is available straight away. So the collating of the information process does take some time, as all the companies have to be notified individually, and they all have to then collate the information and then return it back to you. Of course, if you have properties, valuers, estate agents, surveyors would have to get involved in order to value. And then you would essentially have including also the debts. That's another thing. So if there are mortgages, if there are personal loans, they will also have to be taken into account. And then you'll end up with a schedule of assets and liabilities, and you will start to actually place a picture that the HMRC needs. So one of the aspects of the probate process is that, of course, in this country, the estate is potentially subject to inheritance tax. So inheritance tax account is prepared for HMRC, tax is calculated, and if tax is due, then HMRC issues a reference number and tax has to be paid at that point, either in full or in part before the property is sold. Once that part is done, HMRC officially then allows the next step to apply for probate. And when we say apply for probate, that is a grant of probate that will give authority to then deal with those assets that we have now collated the information about. And once the grant of probate is issued, then we take them to the next step, and we essentially then notify everyone that we now have authority, and we start collating, closing accounts, making claims for insurance policies, selling property, etc. And then once we've got all that information, we pay off any debts that are due. If the estate has been collating income during the administration, we submit income tax returns. Perhaps there's a capital gains tax return. So all the affairs have to be finalised, and then we distribute everything to the beneficiaries. So it is a process from one step to another, and sometimes you can't jump ahead of the process because, for example, like the specific things like HMRC account, unfortunately can't progress any further unless you have the receipt from them. So it is from process from A to Z.
Donata, that sounds really, really complicated. I have a question. Why do so many people think it's a good idea to do this on their own?
Well, I guess sometimes people feel obligated. So, for example, a deceased left a will naming a certain person as executor. They feel personally obligated, as if that is an instruction on me to carry out all those tasks that I've been asked to do. And they feel personally obliged to carry them up themselves. Some people, of course, will think that they're computer savvy, they understand the process if they've had this experience in the past, and they will continue to do that themselves. There are a lot of information out there now online through the government websites guiding you through those processes. But of course, those are guidances, and it's not a guide essentially as you must do this and this is how. And of course you do come across things like you don't know how to complete the inheritance tax return or do the calculation, or perhaps different companies ask for different things and you're not quite sure how to deal with that. So there will be things where people do get stuck. And of course, the best thing is to seek advice when you do get stuck. So it doesn't mean that you have to give everything over and say that, oh, I don't know anything and you can do it. Can you do this for me? And which, of course, is perfectly fine to ask your advisor to help you with all of it. But in some cases, it could be there's just a particular part that I'm not quite sure about. So we would jump in, give guidance, help you go through that process, and then off you go to deal whatever you need. So sometimes it feels obligation. Sometimes, of course, it's cost. And the people think that perhaps they can save something for the estate, and they think, well, I'm obliged to save as much as I can to give to the beneficiary, and I'll try to save on costs. Now, sometimes it's counterproductive because, of course, you have to take time yourself to handle this. And it could be actually that you are working full time, you're looking after children. Dealing with the estate can be very consuming. A lot of information is coming in and out. You have to keep track of things. And of course, you have to, when the funds start to come into the estate, as an executor, you're responsible for holding those funds yourself. So you cannot mix them with your own funds. You should have set up a separate probate bank account. So it can become quite complicated in making sure that everything's done correctly and away from independently from your own personal affairs. So we always say that make sure you take advice when you get stuck. And of course, don't think that actually saving some money that would be offset against something else is actually productive. It could be they'll make you deal with things much faster, much more efficiently. You won't get stuck on the probate process, and therefore you perhaps will save funds in the end in being able to sell the property or sell the shares that you need to very quickly when professional would be able to help you with that.
Yeah. And especially as well, I mean, you know, somebody's died, so you might be in a process of grieving. So you're just adding more stress and pressure on yourself if you then take on this mammoth probate task.
Exactly. It's grief, of course, we know that from personal experience that is an extremely overwhelming emotion. And I see, obviously, on a day-to-day basis, as I deal with families, that each person deals with grief in their own way. And some people will very much say, I want to get through the administrative process to distract me, and very quickly, very efficiently. And some people will be very emotional about it in terms of, how do I deal with all the items in the house? And how do I deal with my brother or my sister or my nephew when they're all grieving in their own way, and trying to actually deal with the process correctly and actually deal with other people's emotions as well as your own. So it can be very complicated from that perspective.
How do people know that they need probate?
So it's not really a sort of a very clear picture. Let's say, in the standard terms, any estate that has more than £5,000 should technically have official grant of probate issued for the estate in order to collate those funds. And the grant of probate gives the official authority for the executor to collect the funds, or if there's no executor, then the rules of intestacy will determine who out of the next of kin would be authorised to handle this. And this official grant of probate then allows that administration to proceed. So in some cases, in fact now £5,000 in this day and age, of course, is now not seen as a very large amount of money. So the banks will now release a lot more funds without seeing the grant of probate. And therefore, if the estate has pretty much liquid assets, and there's a bank account perhaps with £10,000 in it that the deceased have, but there's no property, but perhaps they had a life assurance policy. So if that's the estate consists on those elements, that means that the bank will quite willingly will see the identification of the executor, the will, see that that is the authority that they rely on, and they will release those funds to the executor without the further administration process for the grant of probate. Or if it is an insurance policy that is perhaps written into a trust, then that organisation will release the funds directly to executor or to the beneficiaries of the fund straight away. So in that case, you don't need to go to the formal administrative process of gaining grant of probate from the court. But in some cases where there is property, so there's land transaction that will be required to transfer the ownership of land, so whether that would be a flat or a house, from a deceased name into the beneficiary's name, or to sell it on behalf of the estate, then unfortunately that's not allowed without a grant of probate. By law, you have to have the grant of probate to do so. So you have no choice, even though perhaps your cash assets are quite low and you got the funds directly from the bank, but unfortunately for the property itself, you will need the official grant of probate. The same applies to shares and ISAs that are of large value, because again, shares and investments are treated very similarly to property. So in those, depending on what kind of assets you have, you will need those official documentations to deal with it.
It sounds very complicated because you're saying £5,000. So if somebody has passed away, how am I going to know that? How am I going to, if they haven't left a will, how am I going to know there's £5,000 or there's £1,000 in the bank account? How am I going to know whether they have shares or don't have shares? So how can I then make that decision that, I'll be able to contact the bank and say, look, I've got the death certificate. And again, you mentioned a will or without a will,
Yes.
intestacy. How long does that take? So if you haven't got a will and you don't know, how long could that take?
Right. So exactly. So you actually don't know a lot of information right at the start. It's quite rare for a family member to know unless the deceased really prepared the executor and said, this is the folder with all the information and those are the statements and everything is here. I've written everything down. That's quite rare. Most of us these days don't keep all these types of records, and of course a lot of information is now online, not in paper. So even if the deceased thought, oh yes, it's all very straightforward from my perspective in my own mind and my own affairs, a lot of information may be online. And as I say, there's no centralized system to notify let's say one body that will search everything and will provide you with all the details. So you do have to start off with collating information bit by bit, and it could be that you will have to notify the banks so that they all check whether their details for the deceased within those banks. It could be that you would have to ask for financial institutions to do a broader check on pensions, dormant assets, etc. to have a look, is there anything that I'm missing? I may have known about these bank accounts or this investment, but I might not know overall if there was anything else. So it is becoming, actually, in this digitalized age, a lot more complicated to track everything. So it will take sometimes several months to get to the point of saying, oh, now I kind of understand what it is for sure. And therefore then make a decision as to whether I will need now official documentation to collate everything, or whether I'll be able to deal with just one little part and that'll be it. So if you do need the official grant of probate, this is where the timescale sort of escalate a little bit further, because you were going through an official court process, and the courts will have their own timescales as to how they will deal with it and how quickly. So at the moment we have a two-tier system. We have online system for estates that have a will, and if there is a will that is correctly executed, it will go through an online application process. All the documentation is also prepared in paper and then submitted through online and paper form to them. And it generally takes around 16 weeks for them to process documentation. Some cases quicker, some cases a bit longer. So you're talking about a 4-month period that perhaps you'll have to wait to actually get that documentation. Very frustrating when you can't move forward in that 4-week period to do anything else, particularly if you got a buyer waiting for a property and they're wanting to exchange contracts and you can't. So it can be quite a frustrating process. If there is no will, the only time that you can apply for a grant of probate online if there's only one sole beneficiary. So for example, the deceased left a wife as the sole beneficiary, and therefore then that process is quite straightforward. But if the deceased had left no will and there are multiple beneficiaries, perhaps the siblings that or nephews and nieces inheriting, then it's a paper application process with details of all the beneficiaries and who has the authority then to apply for the official documentation. So that process, unfortunately, at the moment, as we speak, it is much longer than 16 weeks. As it's seen as a more complex situation to investigate, it requires an official that is qualified to assess these things. So it can take, I would say, up to 6 months in order to deal with that. Now, not also to add, if inheritance tax needs to be paid, you have to add, of course, a time frame into that as well, that you will need to complete the documentation for the HMRC. HMRC take around 3 weeks or so to issue a reference number. And then once you've actually paid the funds to them, they'll take another 4 weeks or so in order to provide a receipt. So it's not a quick process. As I say, if you have to deal with HMRC, unfortunately you have to wait and deal with those on a week-by-week basis until you get to the point where you can apply for probate.
I was going to say, you just mentioned you have to pay HMRC first. So if I, for example, had my will and I leave everything to, my sons, supposing they haven't got any money to pay HMRC.
So HMRC want a payment either in full or in part based on the assets that are in the estate straight away.
Okay.
So I guess the thinking is that it could take a very long time to deal with the administration. It could take a very long time to sell the property, and the HMRC would have to wait months, years to get the tax that they need. So if, let's say, the estate has a lot of cash assets, so for example, your sons perhaps don't have their own funds to pay themselves, but perhaps you have some investments that you've put aside, and those investments could be essentially cashed in directly by that bank or investment company, and they pay HMRC directly out of the deceased funds, essentially. Now, if that is not even enough, and there's let's say a property that will be sold eventually, or perhaps the children will want to keep the property and won't want to sell, then you're allowed to make 10 yearly installments of tax. So first and foremost, before grant of probate is issued, you have to make that first installment, that 1/10 of the total value of tax that you'd have to pay. So it's, in some cases, there's a lot of stress involved in the situation, because if there's not enough cash in the bank accounts or investment accounts from the deceased estate to pay those, the beneficiaries have to find their own funds. There are situations when beneficiaries have to take out a loan in order to pay HMRC, and then once the grant of probate is issued and the executors can collate in the funds, sell the property, then the loan will be repaid back. And the estate obviously can finalise it all. So the fact that you would have to take a loan out in order to deal with a deceased asset at the time when it's already stressful and you're grieving, and potentially if in some cases the loan may be assessed against you personally, it becomes a very stressful situation. Another sort of situation to consider is that HMRC would expect the inheritance tax account to be provided to them within a year. However, if it is provided within 7 months, after 6 months, any interest will start to run on the amount of tax that is due.
You have to pay interest
you have
on...
to pay interest
Oh, right,
on the
okay.
tax that is due. So it could be that you don't have enough information to submit the account straight away within 6 months. Perhaps you're still waiting to collate the information or getting the valuations. And perhaps you don't have funds in order to pay in advance HMRC. So it could be late in filing the application, it could be out to 6 months. And therefore interest will start to run from 6 months. If you started to pay the tax in installments, and for example, you've paid one installment, of course, the next year we'll pay the next installment, you will have to pay interest still. It continues to run until you pay the entire amount in full.
And this is why advice is crucial. You might want to do probate on your own, but it is the advice that you're actually losing out on if you do it yourself.
And the timing. So if, for example, you've delayed it in getting to an advisor and you thought, oh, well, I'll deal with it myself. And then all of a sudden 6 months goes by and you think, oh, now I need to deal with this. Actually, I'm now having to deal with HMRC return. You would have already started then to pay interest, which of course it's difficult, isn't it, when the interest starts to run and you think, well, I tried to do my best. But unfortunately, HMRC obviously won't give any allowances for that. It's just very strict.
Sorry, I didn't understand that. So what you're saying is if you start to do the probate, so from the moment there is the death certificate, is time starts the moment the death...
From the date of death.
Ah, right. Okay.
Yeah.
So I was thinking it could be from the time you put the application in. So from the time the death certificate is issued, time ticks.
Exactly.
And so 6 months from there, if there's any inheritance tax payable, you're going to pay interest on it. Don't leave it.
Yeah, exactly.
Don't leave it.
Time is of the essence, and every penny counts. So this is why I think it's counterproductive sometimes not to seek advice straight away, because if you will then continue to delay things, the estate will have to pay other sort of expenses that you may have not expected. Another big thing to also that has come up a few times now is that where the estates of the deceased are quite straightforward straight away, perhaps in cash, and then the property is left to a beneficiary to stay and live in for a long time. So families just think, well, there's nothing to do there. Cash is dealt with, the property is there, what is there to deal with? No need to do anything. Then by the time you get to sell it, perhaps somebody else has died, the occupant has died, you find that the property is owned by the deceased that passed away maybe 5-6 years ago. And then you find that actually then the official documentation needs to be provided, the grant of probate needs to be provided, perhaps even the IHT account needs to be submitted. If the IHT account needs to be submitted and it's outside the first year that you are allowed to obviously apply for the HMRC account, there will be penalties for late filing after the first year. And after 2 years, you will lose some of the tax allowances, which could be quite penalising. So, for example, currently between husband and wife, you can share your tax allowances and transfer them to each other's estate. After 2 years, that's no longer allowed. So each person's individual estate just has their own tax allowances after 2 years, which means that if that was the deceased that inherited everything from their spouse, and they have all the assets against their estate, and they only have their own tax allowances to offset against them. Unfortunately, in some cases, inheritance tax will be payable, even though you didn't expect it.
Oh my.
Yeah. So time is definitely of the essence. Getting advice at the right time, not delaying it, and moving things along as quickly as you can is essential.
So is there anything that you would advise people, apart from doing it as quickly as possible and getting advice, that they need to do around inheritance tax?
It's not a straightforward answer, but the crux of it is planning. Planning, and the simplest thing that you can do is create a will. Even if it is not a taxable estate and it is a straightforward, I leave everything to my wife or to my husband, it straight away, that is a tax-free gift to your spouse. And as I mentioned before, that probate process for those types of estate is essentially simplified and fast-tracked. So therefore, for a simple will, for a straightforward estate where everything passes to each other, that in itself will fast-track the whole process in order to deal with all the documentation, in order to there would be no inheritance tax to worry about straight away. So the simplest thing that you can do is to create a will. And of course, away from that, let's say that would be given to children or other family members, to charities. You can also, your will writer will create a will that is tax efficient, that is suitable to your circumstances, that takes into account the tax allowances. Now, of course, you should review that regularly because tax rules change. Governments change, bring other rules, chancellors change, bring other rules. So those things do change along the way, and you do have to double check whether that is still relevant or it still works for you. So we say definitely review your will every 5 years, or sooner if things have happened where you perhaps received an inheritance. So for example, if you received an inheritance and that bulks up the value of your estate, and all of a sudden you think, I'm outside of my allowances, my estate would have to pay tax. Straight away look at that inheritance and say, do I need it? How will I use it? Or perhaps I want to pass it along to my children. If I want to pass it along to my children, there is a way of creating what is called a deed of variation of a will, whereby you can bypass your estate, and that inheritance that you receive perhaps from your parent can be directly gifted to the grandchildren from that estate. So there are various aspects that you can do in order to mitigate the flow of assets and all the tax allowances that you would could be able to use at any time. So planning is crucial, making sure that you keep track of those allowances and utilize them fully. So for example, on lifetime giving, that if you don't want to grow your capital, you make sure that you take advantage of the lifetime gifts that you can give to your children every year, that if you don't spend all your income, that you also make gifts out of your income every year, and gifts for weddings, and perhaps some gifts for birthdays or special occasions for graduation. Any additional gifts that you will make will be outside of capital and continue to reduce the size of your estate to keep within those tax-free allowances. And of course, things like taking out an insurance policy and writing it into a trust so that it stays outside of your estate, or things like pensions, that you have an allowance that you should utilize every single year that you would place into a pension, and the pension pot can then be outside of your estate directly for your beneficiaries straight away. So again, it's planning, taking advice, whether it be from your legal advisor, whether it be from your financial advisor, to keep track of your estate and to make the use of all those tax-free allowances that are available to you.
Donata, thank you very much. I think the takeaway from that is everybody make a will.
Definitely. Thank you, Karen.